I've got some good news. But not all good news. There's some bad news too. Hello, my fam. It is Perez, the queen of all media, the original influencer, and your number one source for everything It Ends With Us saga. First, the good news. Remember Jed Wallace? He's the social media expert that was hired last year by Team Baldoni and had filed a motion to be dismissed from the gossip ghoul gaslighter's complaint. When she originally filed her lawsuit, Jed Wallace was not named, and now he's not named anymore. The judge just granted Jed Wallace's motion to dismiss from the Mint Julep mistress's complaint, but the motion to dismiss was granted without prejudice, meaning that the self-proclaimed actress of Cherokee descent could bring this forward again in the future. But Wallace and ball-busting Blake still have outstanding litigation in the state of Texas, where Wallace lives and works. And I thought it would be very enlightening to go through the judge's ruling today to see what we could learn and apply to this case, the federal trial that Judge Lyman is overseeing in New York. The judge gives background that Jed Wallace filed his motion to dismiss for failure to state a claim, as well as lacking personal jurisdiction. He briefly surmises Litigation Lively's amended complaint regarding inappropriate conduct towards her on the set of the movie It Ends With Us, as well as the subsequent public relations campaign against her. The judge notes that this is all alleged. The narrative set out below does not reflect the court's own findings, but simply repeats the account of events stated by Lively in her amended complaint. The judge then goes through who all the parties are, the players, Baldoni et al. The judge then also surmises all the drama that happened on the set of the film. And actually, it's very impressive he was able to do this in not that many pages. But here's something really bad. Remember how I made a big deal earlier this year over the fact that the Wayfarer parties only began an investigation into her allegations in 2025? It's clear that the judge thinks the Baldoni Wayfarer parties have a credibility issue. In his ruling today, the judge writes, Wayfarer, Baldoni, and Heath were made aware of Lively's complaints on May 29th, 2023. Then there's a footnote. The footnote says Lively's complaint alleges that Wayfarer and Baldoni's amended complaint makes this acknowledgement that they were made aware of her complaints back in May of 2023. The judge says the court has reviewed Wayfarer and Baldoni's amended complaint and notes that it does, in fact, contain what Lively alleges it contains. Meaning they were aware of her complaints back in May of 2023. The judge then moved on past recapping the drama that went down with production and moves on to promotion and the public relations drama of it all. And this is where Jed Wallace comes in. Remember the infamous scenario planning document? And when the judge is done recapping, we get to the meat and potatoes of this motion to dismiss. Additional evidence submitted by the Wallace defendants. His company, Street Relations, was incorporated in California in 2008, but it has been incorporated in Texas since it was joined as a defendant in this case. Wallace is the only officer, director, or employee of Street Relations, and the corporation's principal place of business is in Texas. Wallace avers that he was contacted by Melissa Nathan, the crisis PR expert, in early August 2024 to read, analyze, and assess media and trends related to Justin Baldoni and potential stories or social media attacks on him. He reviewed all forms of media, analyzed the sentiment of the coverage, and made comments mainly to Nathan. He saw that people on social media organically supported Baldoni and disliked Lively. Therefore, his advice was not to do anything. He concluded work related to Baldoni in November 2024. November of last year is of note because the Penguin expert alleges that this smear campaign against her is ongoing. Well into 2025, she alleges. And still happening, she claims. And that was all surmising what Wallace has said. The judge continues doing that, saying Wallace has an understanding of what a social combat or social manipulation plan could be, but he did not provide such a service related to It Ends With Us, Wayfarer, Baldoni, Lively, or Reynolds. He did not publish directly or indirectly any information or content about Lively, Reynolds, or It Ends With Us. He also did not ask or direct anyone else to post about, comment on, or like any social media posts about It Ends With Us, Baldoni, Wayfarer, Lively, or Reynolds. Wallace states that his role was merely passive observation and analysis of the social media environment. Wallace states he has only visited New York on 4 occasions since 1991 and conducted no business on any of these trips. All of his work concerning Baldoni and Wayfarer in August 2024 was done from Texas. He understood himself to be providing services to individuals or entities in California, namely Nathan and Wayfarer. The judge then details the procedural history, reminding us all of the wonderful litigation that began in December, on New Year's Eve. The judge then explains the legal standard and then gets into his ruling. Quote, the Wallace defendants' motion to dismiss must be granted because the court lacks personal jurisdiction over them. Boom. Personal jurisdiction is claim-specific and defendant-specific. It ensures that there is a connection between each defendant being sued and the place the defendant is being sued so that a defendant is not forced to litigate in an unexpected and faraway forum. Lively's case against the other defendants will proceed in this court, but the Wallace defendants are located in Texas, and Lively has not alleged that they are responsible for any acts that would subject them to jurisdiction in New York. Also, the judge says this for the first time. The alleged negative publicity campaign against Lively largely took place outside of New York. The few alleged actions targeting New York were taken by others, and there are no allegations suggesting the Wallace defendants were aware of them. Therefore, the Wallace defendants cannot be forced to defend this lawsuit in New York. If Lively wishes to pursue her claims against the Wallace defendants, she must do so in another forum or replead her complaint to allege jurisdiction over the Wallace defendants in this forum. And then the judge says, because the motion to dismiss must be granted for lack of personal jurisdiction, the court need not consider the Wallace defendants' additional arguments as to why the motion to dismiss should have been granted. But for good measure, the judge did give some additional reasons as to why the motion to dismiss should be granted, saying the amended complaint contains no factual allegations that the Wallace defendants directed or controlled any conduct into New York or were aware of any actions taken in New York or directed at New York. This lack of control or awareness is fatal under the due process clause. So there was no due process, in addition to lack of jurisdiction. However, at the very end, the judge says, in recognition of the possibility that jurisdictionally relevant facts may be revealed or already have been revealed in discovery, Lively shall have leave to amend her complaint by July 30th, 2025, limited to the existing claims alleged against the Wallace defendants. So, the clock is ticking. If she wants to move this forward, she's got just 2 weeks. She probably will, right? So overall, this is a win, I think. What do you think? Let's discuss in the comments.